I'm Rich Daly, and this is FastFinance, your quick hit of the news and numbers that matter the most in healthcare finance. Up first, weird numbers. $10 million. That's the maximum annual penalty for health plans that fail to meet pricing disclosure rules in the quickly advancing Patients Deserve Price Tags Act. Other advancing legislation also would increase fines for hospitals that fail to meet pricing disclosure requirements within them. Now for today's main story. An appeals court recently barred rebate programs by drug manufacturers who do not first obtain federal approval. And that case could have major ramifications for the federal 340B rebate program. On July 21st, the U.S. Court of Appeals for the D.C. Circuit upheld a lower court ruling that barred alternative 340B rebate models that don't first obtain explicit approval from the Health Resources and Services Administration.
That's certainly welcome news from a provider perspective, in the sense that there were 5 manufacturers last year that had attempted or expressed interest in proceeding with converting 340B from an upfront discount program into a back-end rebate program. And they did not believe they needed permission from HRSA to be able to do so. And those rebate models would have imposed some significant financial hardships on providers, cash flow issues, concerns about rebate rejections.
That was Jeff Davis, a partner with the law firm Bass, Berry & Sims. However, the decision also confirmed that HRSA has the ability to permit rebates so long as they are approved by the agency.
The decision did confirm that HRSA does have the ability to permit rebates so long as they are approved by HRSA. And so this decision did not at all limit HRSA's ability to proceed with the rebate pilot program that they are, currently in the process of working on.
Following HRSA's withdrawal of a 340B rebate pilot earlier this year, and that followed hospitals' challenge of it in court, the agency has relaunched an effort to retry it. That new effort presumably aims to address the procedural concerns that court had raised to it. Part of the effort to address those concerns included a recently finished information collection request that solicited feedback on the pilot. A multitude of lawsuits continue to advance that would affect various aspects of the 340B program. Davis highlighted several groups of lawsuits that executives should be aware of. One group of lawsuits focus on whether drug manufacturers can impose limits on contract pharmacies despite HRSA barring such restrictions. Another group of lawsuits focus on the legality of 21 state laws that prohibit contract pharmacy restrictions by manufacturers. Drug makers have challenged those over the belief that they are preempted by federal law. And another type of 340B legal challenge came in April when AbbVie challenged the HRSA definition of the 340B patient as too expansive.
At its core, the ability to generate the 340B benefit is dependent on providers' ability to dispense a 340B drug to an individual who is a 340B eligible patient. And so if the definition of a 340B eligible patient is shrunk, then that will mean fewer prescriptions that could be filled at 340B pricing, not just through a contract pharmacy, but also through hospitals' in-house pharmacy or in the provider's clinic setting as well.
The newest type of 340B case involves a hospital challenge of drug maker requirements under state law. Earlier this month, Tampa General Hospital sued Eli Lilly, alleging the drug maker unlawfully cut off 340B discounts after the hospital refused to provide newly required prescription-level claims data through Lilly's reporting platform. Those legal challenges bear careful watching, since the outcome could fundamentally reshape the 340B program for hospitals and health systems. And now before we go, just one more thing. Federal reductions in allowable provider taxes were detailed in a newly issued proposed rule. The rule would implement the One Big Beautiful Bill Act reductions in the allowed amount of provider taxes in Medicaid expansion states from 6% to 3.5%. Rates in non expansion states would only be frozen at the current level. The $220 billion reduction in 10-year Medicaid payments to providers from implementing the provisions of the new rule include $163.7 billion less paid by providers in taxes and $56.6 billion net decrease in Medicaid revenue. Starting in FY28, Medicaid expansion states must begin to lower tax thresholds by 0.5% each year until reaching the new statutory limit of 3.5%. The proposed rule also would nix a regulatory guideline that allowed certain taxes to exceed the 6% threshold if at least 75% of providers subject to that tax did not receive back at least 75% of their taxed amount. On a quarterly basis, states would need to file detailed class-level reporting on tax revenue collected, net patient revenue, and information on how tax funds are applied. The reporting would have to use actual data and not estimates. Another provision in the proposed rule would formally establish health insurers as a taxable class, and that would ensure states can tax insurance premiums or covered lives. Comments on the rule are due September 21st. Well, that's all we got for today. Don't forget, you can get your FastFinance newsletter delivered right to your inbox every Wednesday. Sign-up info is in the show notes below, or you can go to hfma.org. I'm Rich Daly. Thanks for listening.